Good afternoon, everyone, and welcome to the fifth edition of Dispute Resolution Dialogue Series. The TrustBridge TRD series is a series of conversations dedicated to exploring key legal and policy challenges shaping the landscape of arbitration and dispute resolution. Today, we have with us Professor Harisankar Sathyapalan, Professor of Law, and DC Singhania, Chair on Alternative Dispute Resolution at National Law School, Bangalore. If you have been following recent legal developments, you may have heard about a judgment from the Supreme Court of Singapore on plagiarism. But what does it mean for legal ethics and dispute resolution? And that's exactly what we'll be unpacking today with Professor Satyapalan's expert insights. So let's dive in. Professor, over to you.
Thank you. Thank you, Prashant. Thank you for having me on this dispute resolution dialogue. So let me just share my. I'm sorry, there's some technical problem here. May I ask Suhani if you have the slides? I don't know.
Yes.
Settings problem.
No problem.
Yeah.
She will.
Is it visible?
Mhm.
Yes,
No.
yes. Thank you. Right. Just to give you a context of this talk, so this is a precursor of this talk is actually an opinion piece that I published a few weeks ago in the Hindu business line on the topic of judicial plagiarism and its implications in international arbitration. And as Prashant rightly mentioned, this particular piece and the talk is based on a particular case decided by the Singapore Court of Appeal recently, and a couple of other cases also from the same court on copy pasting of arbitral awards and setting aside of those awards based on the lack of due process and violation of principles of natural justice. So just to give you a background, can I ask you to please change the slide? Yeah. Yes. So this is largely about not just about copy pasting, but it is largely about the quality of arbitrators. And this is a frequently used maxim in international arbitration literature, which is an arbitration is only as good as the arbitrator. So the fundamental question is that is there a perfect or an ideal arbitrator, or are there any qualifications required for an arbitrator? So the question largely is who can be an arbitrator, and as this maxim suggests, the arbitration and the disputing parties and their expectations are largely based on the quality of arbitrators that we have. Next slide, please. Right. So the fundamental question again, who can be an arbitrator? So if you look at the law, both the National Arbitration Law, which is the Arbitration and Conciliation Act, and the model law. So the National Arbitration Act, the Arbitration and Conciliation Act, as you might know, is based on the UNCITRAL model law and international commercial arbitration. So neither of these legal instruments suggest any qualifications, special qualifications for an arbitrator. So anybody can be an arbitrator. So it simply says in Article 10 and 11 or section 10 and 11, it talks about the number of arbitrators, and it basically says that a person of any nationality can be an arbitrator. But one of the fundamental requirements or one of the fundamental obligations of an arbitrator or the arbitral tribunal is that it must be independent and impartial. So these two terms often used together, independence and impartiality. So it generally refers to, one is independence is basically a more objective standard. It talks about the possible conflict of interest based on any kind of relationship that the arbitrator may have with the disputing parties or the lawyers involved in the arbitration. For example, an arbitrator, if he's a law firm partner and if the lawyer is a junior associate or an associate in that law firm, then these are certain relationships which are prohibited. And these relationships, these conflict of interests are regulated through a soft law instrument called the International Bar Association's guidelines on conflict of interest. And there are also issues about impartiality, which is largely based on what we call as issue conflicts. For example, if somebody has a particular viewpoint on a particular issue, which is the relevant issue in an arbitration. For example, if an academic is appointed as an arbitrator, and as an academic, if somebody writes an article on a particular issue and that particular issue is the issue relevant for consideration in the arbitration, then those are certain things that may be raised by the opposite party to challenge the appointment of an arbitrator. And there are examples like, for example, in a recent arbitration, not a recent arbitration, in one of the arbitrations where Republic of India was a party, and Republic of India basically challenged the appointment of the opposite party's nominee as an arbitrator because that arbitrator wrote an article on the principle of necessity in international law. And the principle of necessity was in fact the main defense for India, and India felt that that viewpoint by the arbitrator is going to come against the interest of Republic of India, and the Indian government could successfully challenge and remove the arbitrator. So these are some of the fundamental requirements to make sure that there are no conflict of interest, to make sure that the arbitrator and the members of the tribunal are free from any kind of bias. So therefore, there are two questions. One is, are these conflict of interest? If it is not determined at the beginning or during the process of arbitration, what happens to the award? Is there a possibility of challenging the award? Like in the case of a court judgment, do we have any judicial remedy where the judgment can be appealed and reversed by a higher bench? So these are some of the fundamental questions that we are going to address today. So questions like, what if the arbitrator is biased and has not been removed? So the resultant award would be a disastrous award for the party, and with no real judicial remedies like an appeal against such an award, because appeals are not available in arbitration, although we have certain post-award judicial remedies like setting aside of an arbitral award, which is unlike a real appeal that happens in a court litigation. Next slide, please. So so this is the case that I was mentioning at the beginning, and this is the case that led to this controversy of copy pasting in arbitration. So the dispute was between, so this is a typical Singaporean style of naming cases because they respect confidentiality. So the appellant in this case is DJP and the respondent is DJO. So DJO basically is an Indian government entity. It is a special purpose vehicle created for managing the dedicated freight corridors in India. And DJP, which is the appellant in this case, is a consortium of foreign companies who basically secured a contract with the Indian government entity. And the contract, it was a pure commercial contract. Contract had a arbitration clause embedded in it, and because it was a foreign contractor contracting with an Indian company, the dispute resolution clause mentioned that the arbitration must be under the rules of ICC, which is the International Chamber of Commerce seated in Singapore. So they had several options, but in this particular arbitration, it was a Singapore-seated arbitration, but administered by ICC, because there is a general rumor or misconception in this regard is that it was a SIAC administered arbitration because it was seated in Singapore. Interestingly, it was an ICC seated arbitration, because this point is also important in our discussion. So the arbitral tribunal, the 3-member arbitral tribunal in this arbitration awarded in favor of I think there is a typo in this slide. It was in favor of TJO, which was the Indian company. And there were 2 parallel arbitrations because Indian company had multiple contracts with other foreign contractors as well as domestic contractors. So as you can imagine, the real issues in all these arbitrations were overlapping. There were similar issues, similar parties, and more interestingly, there was one arbitrator, a former Chief Justice of India, Mr. Deepak Mishra. He was the president of all 3 arbitrations. So we are talking about 3 arbitrations here. There is one arbitration which is the basis of this particular judgment from the Singapore court, and there were other 2 parallel arbitrations. And in all 3 arbitrations, there was one arbitrator who was, the same president basically led the arbitral tribunal, but other arbitrators in the other 2 arbitrators were, they were from different backgrounds. Of course, in this particular arbitration, again, the 2 co-arbitrators were 2 former judges from 2 different Indian high courts. Not very relevant, those names. Yes, so this factual background is important for further discussion. Next slide. So the consortium of foreign contractors, because of their unhappiness, they got an award, an adverse award in their against them. So they moved to the Singapore High Court, and as you know, as a fundamental principle of international arbitration, the court at the place of arbitration has the competence to scrutinize that award, not as an appellate court, but to make sure that the arbitrators conducted the procedure in accordance with the principles of natural justice, to make sure that there were no jurisdictional or procedural irregularities. So this is how an appeal is different from a setting aside application. In an appeal, as you might know, the higher court has the opportunity to look at the issues afresh on the facts and on legal points. But in the context of arbitration, that judicial remedy is not available. So the only remedy available at the place of arbitration is that you can move the relevant court at the place of arbitration to ask the court to review, not as an appellate court, but to review the judicial and procedural irregularity. So there are certain limited grounds available under the UNCITRAL model law. So since it was a Singapore-seated arbitration, the law in question was the Singapore International Arbitration Act, and similar to the UNCITRAL model law and the Indian Arbitration Act, they also had grounds such as principles of natural justice. Principles of natural justice, by the way, is not a specific ground available for annulment of an arbitral award, but lack of due process, such as if the arbitrator has not conducted the proceeding in accordance with the agreement between the parties. That is one of the crucial grounds. And obviously, you have one umbrella clause, which is the public policy. So these were the two grounds on which the aggrieved party, the consortium, basically approached the court, asking the court to set aside the arbitral award. So in this case, as you might know from the literature, from the article and other literature were available on this particular topic, almost half of the award was reproduced from the other two parallel arbitrations that I mentioned in the previous slide. To be precise, 212 paragraphs were copied verbatim from the other two parallel arbitrations. So the total length of the award was 451 paragraphs. Out of that, 212 were blindly copied from the other two arbitration awards. So the advantage of the president of the arbitral tribunal, which was the ex-CJI, Mr. Deepak Mishra, he was the president of the other two arbitrators. So he had, of course, access to the material and the awards which he drafted. Based on this, the party argued that this is against the principles of natural justice and due process. The court basically set aside the award on this basis. And interestingly, the court made this observation. The court made this observation saying that copy pasting itself is not a ground available under the Singapore law or even under the unsettled model law for annulling or setting aside an arbitral award. But in this case, the court observed that there are certain problems with the award that would have caused a fair-minded, reasonable, and informed observer to apprehend that the tribunal had approached the matter with a closed mind. So a basic tenet of the principles of natural justice is that the judge or the arbitrator must be disinterested and unbiased and to apply mind in deciding the case, in adjudicating the matters afresh, which was not the case in this particular case. So the ground is not plagiarism itself. It is not because of copying and pasting, but because of the copying and pasting, substantial copying and pasting from the two previous awards, the court concluded that the arbitrator did not apply the mind, and therefore it was against principles of natural justice. Next slide. Again, they went to the Supreme Court, the Court of Appeal, basically. And the Court of Appeal upheld the decision of the High Court, and they again found that the integrity of the arbitration was compromised because of the three reasons. And they again decided to, they did not decide to set aside because the setting aside was already pronounced by the lower court. They upheld that decision. Three things. One is prejudgment amounting to apparent bias. So, as I have explained in the beginning, conflict of interest or justifiable doubts as to independence and impartiality is a fundamental obligation or a requirement in international arbitration process. And generally, these issues such as independence and impartiality are tested on the grounds of conflict of interest, and such as any kind of financial relationship or other relationship between the parties and the arbitrators, and things like issue conflicts, etc. But in this case, it is not just a question of bias or the bias in the context of conflict of interest, but they held that the prejudgment, the fact that this person or the president of this tribunal had access to the material, so he had already made a judgment because of the fact that there were overlapping issues, because the genesis of the dispute was the same. It was about managing freight corridors and the relevant parties involved in that, and there were also some overlapping counsels arguing for the parties. So because of this, as a matter of shortcut, taking a shortcut, the president basically prejudged, and therefore he did not apply his mind, and that amounted to apparent bias. Secondly, and more interestingly, reference to extraneous considerations. The arbitrator did not basically applied his mind that basically because of the fact that there were many issues in the dispute that were unrelated. For example, certain figures in the previous two arbitrators were not matching with the current arbitration. And some of the other contractors, subcontractors, or unrelated parties. So there were many issues which were not relevant for this particular arbitration, which was when blindly copying that 212 paragraphs from the previous awards to this current arbitration, that basically demonstrated that the arbitrator, even though he had access to the material, but those material were not really relevant for this current arbitration. And the third one was the unequal position of the arbitrators. As I said, the president of the arbitral tribunal was the president of the two previous arbitrations, but the two co-arbitrators in this particular case, which was retired Justice K. Lahoti and retired Justice Geeta Mittal, two former Chief Justice of two Indian High Courts, were also involved in this arbitration. But interestingly, they did not have any access to those previous awards or the materials related to those arbitrations. So in that sense, this arbitrator, so that also shows that the integrity of the process was compromised. Where one arbitrator had direct access to the material, the other two arbitrators had no clue what was happening in the previous arbitration. They did not even have any information about the two previous arbitrations. So that also kind of compromised the integrity of process. Therefore, the Chief Justice of Supreme Court of Singapore's Justice Sundaresh Menon decided that this is against the basic fundamental requirements of, or it undermines the legitimacy of the arbitral process, and therefore the award was set aside. So this is what happened in the story. Now, my argument in that particular opinion piece was plagiarism itself, or self-plagiarism, is not something which is, I mean, it is something that is followed in academia. I'm not saying that self-plagiarism is an acceptable thing, but for example, when academics, when they self-cite, their intention is to sort of, but they acknowledge the fact that it is copied from previous literature by the same person, but the fact that it could be because of their intention to establish themselves in a particular field, or to emphasize stress on a particular doctrine, which is also relevant, or which is prevalent in judicial process, because as you can see in Indian court judgments, on particular points, on particular doctrines, Indian judges frequently, not just Indian judges, other common law courts also, because as a matter of developing jurisprudence in a particular field, they frequently cite their own and copy paragraphs verbatim from the previous judgments. And this is valuable in a judicial context, because judges are not just there for resolving disputes, but they also create law and develop jurisprudence. Contrastingly, in arbitration, as we all know, it is a private dispute resolution mechanism. Their only job is to resolve disputes. And international commercial arbitration particularly, because it is not in the public domain and it is not going to create jurisprudence or develop jurisprudence in that sense, there is no need for an arbitrator to self-plagiarize, even if they self-plagiarize or copy from relevant material, it is important that they attribute. Two things are important here. Unlike court judgments, court judgments, as we know, are always, there is a judicial remedy available against court judgments, but in the case of private dispute resolution mechanisms like arbitration, there is no such judicial remedy. The only judicial remedy available is the process of annulment, and this process of annulment again is limited to very limited grounds. And as I said, plagiarism is not a ground, or bias is a ground, but it is very difficult to relate plagiarism with bias. So unlike the Singapore court, it is not unlike, the court in Singapore basically interestingly connected these two aspects of bias and plagiarism, but it is not very easy for any judge to make that connection between copy pasting and bias, because integrity of arbitral process is not a particular ground. So as I said, so this distinction between appeal as a judicial remedy and setting aside as a post-award arbitral remedy is very crucial in this context. So the availability of or non-availability of a ground such as plagiarism makes it difficult for parties to get a quality award. Therefore, I don't see any reason for an arbitrator, whether it's a retired judge or not, to basically copy materials from other sources and make an arbitral award. Therefore, recycling award content without contextual reasoning is ethically flawed, and procedural shortcuts in arbitration undermines the legitimacy of the arbitral process. Next slide. Right. So this is the fundamental problem. So Indian disputing parties, not just Indian disputing parties, but Indian courts also, they for some reason prefer appointment of retired judges as arbitrators. Why Indian courts? Because Indian courts have the competence to appoint arbitrators under the law. Under Section 11 of the Arbitration and Conciliation Act, they can appoint arbitrators. And if you look at the data, in most of the cases when a Section 11 application is made and the appointment made by a court, so the nominated arbitrator is usually a former judge of the High Court or the Supreme Court. The problem with this is, I'm not saying that retired judges are a problem, but the real problem is they come with what we call as a judicial baggage. They bring certain judicial habits. For example, in arbitration, there are flexible rules. It is not mandatory for an arbitrator to follow rules of evidence or the provisions of the Code of Civil Procedure. But let's suppose a person with a long career as a judicial officer becomes an arbitrator. It is very difficult for him to be more flexible with respect to the Civil Procedure Code and not applying the Civil Procedure Code or not applying the rules of evidence. Therefore, that judicial baggage is the real problem. And we know that for the past few years, everyone, Indian Prime Minister, Law Minister, President, everyone talks about making India a global hub of international arbitration. And one of the important ingredients for making any jurisdiction a global hub of arbitration is to train arbitrators, to have a better institutionalized mechanism where you have younger lawyers and other persons from expertise in different fields to become arbitrators rather than relying on retired judges. So arbitration must become a craft, not a legacy post. So with that, I conclude my presentation. We can open it for Q&A.
Thank you so much, Professor Sathyapalan, for your fascinating insights. We do have some questions from the audience. First question is about you mentioned that arbitration is a system where precedents have little role. It doesn't follow the doctrine of stare decisis. So the reasons for a prior decision, if it doesn't need not affect the decision-making process in a fresh arbitration, even if it overlaps with similar claims, parties, and relief sought in a parallel arbitration. So recycling the contents of a previous award is thus unreasonable and detrimental to procedural integrity. But in practice, arbitral awards do shape informal industry norms. Okay, so the question says that even though arbitration doesn't follow stare decisis or doctrine of precedence, but arbitral awards do shape informal or industry practices and norms.
I agree with that. So there is this idea of lex mercatoria, or law made in the market. But the reason why we say that arbitration does not follow a principle of stare decisis is that arbitral awards are not in the public domain. Only the arbitrator in a particular case and of course the disputing parties and the lawyers involved in that process will know the facts and the actual award, unless it ends up in a court of law. So that's the paradox of arbitration law. Arbitration is a private process, but arbitration law, when it is decided in the process of an annulment or enforcement of an arbitral award through a court of law, it becomes part of the arbitration law. Otherwise, arbitral awards are purely private and international, although there are arguments in favor of publishing arbitral awards. International commercial arbitration awards particularly are not in the public domain, and therefore this idea of precedence is not applicable to commercial arbitration. But I agree with the point that there is something known as lex mercatoria, or the rules of the game in a particular industry that players in the market or in a particular association or industry follow, and arbitral awards also contribute to that. But unlike court judgments, they don't belong to that category of precedence.
Manish, you have a question, please go ahead. Sure.
Yeah, I have a question and an observation. The observation, am I audible?
Yes.
Yes.
Yeah.
Okay, my question and observation is that while you said, initially you said that the names of the judges are not important, and then subsequently you named them as well.
I said the two co-arbitrators, I mean, their names were not important. But
Not important.
Yeah.
But let me tell you why they are very important.
Please.
They are very important because this was on hearsay. Of course, I have nothing to substantiate it. When in Singapore this matter was argued, they said, why should we publish the name? So insofar as when it went to the High Court, the names of the judges were not there in the public domain.
That's right.
Now the question is that this is again a club.
Yeah.
So therefore they said that you want publicity, and then ultimately, insofar as the Container Corporation, they said that so under duress or under influence or under instructions, the names were not provided. However, by that time in the entire arbitration circles and everybody, those names became prominent and relevant, and everybody knew that who those names were. Therefore, in appeal, as a second thought, they published those names. So the only point is that ultimately when you name them and you get those names, you'll find that it is not only recirculation of arguments and awards, it is recirculation of those same judges as well.
Yeah.
There is one more difficulty which is there, which arises, is that I will tell you why names should be there or should not be there. Personally. Now, when these names came out, the question was, do you know what is the consequences of this kind? The other judges, do you know what is their sin? The two judges? They signed the award without reading it.
Thank you. Yeah.
So therefore, what I'm trying to say is I can understand there was a cut, copy, paste. 274 paragraphs. In those paragraphs, arguments with respect to a matter which they had not heard. This is intellectual bankruptcy. Right. So ultimately, unless you are this is the only forum that where I've seen this formally being discussed. I hope it will not be published and my name will not be there. So I'll be honest. No conference talks about it. No conference speaks about it. So as a result of which, this is the malice. So ultimately what happened is that the two retired chief justices put their signatures on the dotted line. All that what they were interested in was their fees. Except that opportunity of heard, leave alone, they did not hear or they did not bother. It was an outsourced award.
Mm-hmm.
So therefore, it was completely outsourced. And insofar as had it not been, let us take, for instance, if that award was in India and it is $100 million award, Delhi High Court judges would have danced and said that first you deposit that money before you go and appeal. And a 34 in Delhi High Court would have lied there for 6 years. Which judge would have decided? So the cost of money, the present value of that money, if it would have been discounted, it would have become zero. So therefore, today, insofar as the opinion which comes is that all these judges, insofar as in arbitration, they all consider it to be easy money. They do a cut copy paste job is not bad. It is not perjury, not perjury, but plagiarism is also not bad. But they did not even care to read what was written in the award. Why has nobody picked up this point and criticized? And do you know what is the consequence of this? This matter will now go back for the appointment of fresh arbitrators, and this 3-4 years of exercise will start all over again. So therefore, what you do not realize, so ultimately, had this been in Delhi, the first question, or assuming it was in Gurgaon, or God forsake if it would have been UP, in Ghaziabad district, the money would have been deposited for 7 years, nothing would have happened. By that time, something would have happened, and Allahabad High Court would not have touched it for another 6 years. So you don't have your systems, processes, integrity in place. So therefore, if you are not ready to go to the market, because arbitration, international commercial arbitration is a market, it is not that justice and things of that nature. The government must realize that it is not ready for this market. You cannot go to the market with a flawed product. End to end, it is a service. It's a service industry. So
Absolutely, yeah.
So if it is going to be a service industry, Singapore, in their annual budget, there is a line item that this is what is they're going to make out of tourism. That is not that legal tourism. United States of America, United Kingdom has a line item that they will make around about $2 billion out of justice. What is your investment into the justice system? In this arbitration system, you have spent 7 crores for the purposes of looking at the fact that we will make arbitration as the hub. But it's a complete waste of money.
Manish, a couple of other questions as well from other people.
I apologize. My apologies.
But very valuable insight and some important points you have raised.
Absolutely agree with that. I also have some additional points to maybe later, not particularly on the judges' points.
Sir, my apologies.
Yeah,
No problem. But some of our young audience also have some interns also have some questions. So one question is about pre-award scrutiny. Many institutions, arbitral institutions have pre-award scrutiny. In this case, was it done? Was it there? Not there? And as a matter of good practice, best practice, this would have saved, all that inconvenience caused to the parties.
Excellent point. So I was about to talk about that. So as I said, this is because there were a lot of controversies or some rumors in the circle saying that because this was a Singapore-seated arbitration, many people believed that it was SAAC. It was not. Again, I'm not. I mean, of course, at NLS we have a long-term arrangement with SAAC, so I know how process happens there. This was an ICC arbitration, and as the questioner rightly pointed out, there is a pre-award scrutiny process even in ICC arbitrations. So it is done by the ICC court. ICC court consists of prominent arbitrators and lawyers from different jurisdictions across the globe, from civil law and common law systems. But interestingly, there is no discussion, there is no, as the previous questioner was saying about the judges, there was nothing in any of the conference or any literature about the involvement of the ICC court in scrutinizing this award. This is a major flaw, I believe, because as Mr. Lamba mentioned, the Indian system, so there is it is kind of a mafia. It is an elite club where you have retired judges, unfortunately, the main players in the scene, but you have a very prominent arbitral institution administering this particular arbitration, and it is surprising, at least to me, to know that the ICC court was not involved in the scrutiny of the award, or maybe they've scrutinized the award and they could not find problems with the award. Yeah, no information available on that, but there was supposed to be an ICC court scrutiny because it's part of their process.
So then it's also failure on their part.
Exactly. And the two other arbitrations, again, one difficult problem could be, again, I don't think this can be used to justify ICC's lack of scrutiny, because the other two arbitrations were actually New Delhi based. I think it was the India Institute or some Indian institution, because it was a domestic arbitration. The two parallel arbitrations where Justice Mishra was involved as the president. But every material that happens through the ICC court is available to the ICC court. They should have scrutinized the award before releasing it.
So, Professor, as per the Indian law, a party cannot have the same arbitrator in more than 3 matters. But these are 3 parallel arbitrations.
I'm not sure of any such restrictions under the
interest under 6th schedule, if I'm not wrong. There are conflict of interest rules, right, under the schedule.
Yeah. Okay. On the basis of the Schedule 5 and Schedule 7 of the Indian Act,
right,
conflict of interest.
Right. So party cannot have. So typically how parties evade this rule is they ask the law firms. So the law firms have the same arbitrators, So law firms engage the arbitrators, and those arbitrators are engaged repeatedly.
Repeatedly,
and
yes.
That's how they evade the conflict of interest and yet manage to have the favorable arbitrators. But in this case, it's the same party and the same arbitrator.
Yeah, so at least the respondent in all 3 arbitrations were the same party, because it was the government entity, the freight corridor special purpose vehicle. The repeat appointment as such is, I don't think, because if you look at the IBA guidelines or even the Indian schedules, it talks about a kind of a traffic light system. You have a red list, an orange list, and a green list. So repeat appointments, as we've mentioned, in the Indian context, it is the same people. And if you look at the international arbitration industry as a whole, you have few people, they get repeat appointments in all these high-stake matters. So repeat appointments as such, although it could be a problem under the IBA guidelines, but I don't think that is there is any specific ground which sort of prohibits the appointment of an arbitrator in a future arbitration. But it's a good point. But again, the other party did not challenge. So if the other party has not challenged the appointment of an arbitrator at the beginning or during the process, the arbitrator can continue with the process.
Okay. So next question is, so what would be the implication of, this instance? Will there be plagiarism detection reports in future now?
Yeah, it is for the institutions you don't actually require plagiarism because these are certain blatant copying. So if anybody, a case counsel, a case management team, if they look at the two awards or the submissions made by the parties, they can easily identify these plagiarized paragraphs from the previous awards. So yes, detection softwares are also important, but what is important, the implication of this award should be the institutions, particularly when they are administered through global institutions like ICC, they must strengthen their scrutiny process.
Professor, you had differentiated, when you talked about precedentiary value, when you said that precedents are useful in litigation because, the law is cited and the jurisprudence is developed. In this case, because the three cases involved same parties and similar issues, so factual context was probably, and I'm assuming this because I don't know the facts and the awards, but assuming it involves same parties and similar issues, so probably the factual context was similar. Now, I understand that the other two arbitrators, of course, had no excuse because they were not party to the other. But was it possible that because the issues were very similar, so therefore it skipped their scrutiny, and because the issue was similar, and hence the presiding arbitrator could use the same facts, and it's not cut copy paste on the law point, but it's maybe just on the factual point.
Yeah, I'll just make one point. Yes, that is precisely the reason why Justice Misra decided to take this shortcut. But there is a fundamental problem here. The two previous arbitrations that we mentioned, they were domestic arbitrations based in New Delhi. Therefore, the lex arbitrae, or the arbitration law that was supposed to regulate that process, was the Indian law. But the third arbitration, or the arbitration in question, was the Singapore Seattle arbitration. So the application of law itself was different. But while copying the 200 odd paragraphs from the two previous awards, which were India-based awards, or in other words, were the applicable law with respect to the process of arbitration was the Indian Arbitration Conciliation Act. And that application, because application of law is an important, crucial part of the decision-making process, that itself went wrong when they basically copied the two previous awards. And what was the other part of your question?
Just asking that it was factual matrix that they might.
Yeah. Again, on the factual metrics point, it was not the same parties. Of course, one party was the Indian government entity or the special purpose vehicle, but the claimants in the other two arbitrations were two different parties. The relief sought in all three arbitrations were the same because the Ministry of Labor had amended the minimum wages policy for the contract workers, and all three contractors basically were asking for additional payment. So this was the fundamental dispute. But there were, of course, difference in the payment and the figures involved in the payments. So although the genesis of the dispute was the same, but not identical parties, there were multiple parties involved, and the actual computational questions, and most importantly the application law was different. So there is no excuse for the arbitrator to blindly copy and paste these figures and the paragraphs from the two previous awards.
Reasoning and law could have been copied, but not the facts and the submissions. So they copied submissions which were not made before them.
Sakib?
Sir, my question is that given the limited grounds for setting aside an arbitral award, do you think that it's time for institutional arbitration rules or national laws to explicitly include ethical drafting standards, such as to provide original case-specific reasoning as a part of procedural fairness?
Um, uh, A good suggestion, but even without that rule being made in an institutional rule, it's a matter of professional conduct. Although Sundaresh Menon made the specific point that we are not uh, setting aside the arbitral award for the lack of professional conduct or professional misconduct. So my opinion is that it's a matter of you're doing a professional job as an arbitrator. It is expected out of you that you apply your mind and apply the facts to the the law to the particular factual situation. So these are certain things that all professional must keep in mind. But the point that maybe in the future the institutions will have a specific rule to say that okay, plagiarism is not allowed. Or drafting the award carefully can be made a part of the institutional rules. But my point is this is a matter of sheer professional conduct.
Thank you, sir. Thank you.
Okay, so I think no more questions. So
Thank you so much, sir, for joining us and engaging all our questions. It was a pleasure having you here, and thank you for taking the time out to be with us. Could I request